Give them a chance to get settled in.
I'm ready to go.
Okay. All right, you tell me when you're, all right. Good morning, everyone. It is 9:04 a.m. and I will call the Sewage and Water Board Governance Committee meeting to order. Special counsel, please call the roll.
Director Scruggs,
Present.
Director Cole,
Here.
Director Kennedy, Director Thomas,
Present.
Director Stewart.
Present.
Chair, you have a quorum.
All right, so let's jump right into our two discussion items. First, we'll start with our General Superintendent Compensation Framework and Employment Contract. You should have a packet in front of you that includes an executive summary of the contract terms and then a draft work in progress for our General Superintendent. Let me give you a little bit of context for our discussion today. You are not being asked to review this contract in detail. This is not a drafting committee. What you are looking for is consistency with the board's decision-making, which has been to appoint the general superintendent, and also the approval of our compensation framework, which includes our KPI, evaluation cycle, et cetera, et cetera. Okay, so you want to look at this and make sure that the draft, as represented by the summary, is consistent with that. Feel free to look page through, and if there's anything that jumps out to you, questions that you want to ask, you can ask them now, and we can discuss, or you can provide them to special counsel. The only other thing I want to note.
You just wanted to acknowledge that.
Oh, I'm sorry.
Yes.
Please let the record reflect that Director Greenwich is also present with us today. Thank you for being here. So also want to point out to you that as far as compensation is concerned, there has been no change to compensation from the interim compensation framework that was put in place by the board upon Caitlin's interim GSO appointment. We're really looking at the performance evaluation framework and how that's been tied to compensation. And then also you will recall the board approved the performance-based compensation adjustment as reflected there, the 0, 1.5, and 3% adjustments accordingly. Benefits are the same. There's been no changes there. And then there are some special terms around termination and transition that are relevant to our part of the framework to ensure continuity, right? So we wanted to ensure that we position the organization to be insulated from rapid departure, right? So we have included a notice provision that is a 90-day notice with some accountability, not too much, but some accountability measures in there to incentivize our executive to give us a heads up if she decides that she wants to move on, okay? All right, so we'll take time for you to look at it and ask questions. At the end of that, if all hearts and minds are clear, we'll just ask for a recommendation to process this to the board for approval. And Caitlin, if you wanted to say anything or make any comments, feel free.
No, thank you. I think this reflects the conversations that have previously been had with the committee and Director Scruggs, so.
Does the total current compensation include I guess it was a longevity
Yes.
increase?
Thank you.
I know there was confusion around
Director
that.
Cole, yeah. So let me give you a little bit of insight, and maybe Director Heyman can speak to this. So there was an open question about the applicability of a longevity bump. Our interim general superintendent received that because she has been here for 6 years, right? And so almost or 6. So City Civil Service provides a 2.5% increase at the 1-year mark, the 5-year mark, and then maybe the 10-year mark. And so she is receiving that currently, which is why her total compensation is $246,750. And so there's open question as to whether that would carry forward, whether it should be applicable to unclassified executives and the like. So Mr. Callahan provided guidance to Director Heyman at our request that lays out the applicability and like, not just for that, but also for the certification question that we had, certification bump. So the conclusion I drew from that correspondence, and Director Heyman can speak to it if he'd like, is the longevity applies to unclassified employees, the certification increase does not. And so the 246,750 is where Caitlin is today, General Superintendent is today, and that's where we would maintain her compensation.
And that's correct.
Okay.
I'll just ask David, do you have anything else to add?
Nothing to add. The certification part is something, again, that per civil service can be considered by you at the time of hiring and in terms of baking it into the salary you all decide on, whatever that's worth and whatever you feel it's worth. And then subsequent certifications, should they be deemed of value to the organization and the executive wants to bring that forth after those are subsequently gained, that can be considered in pay increases, later pay increases, largely due to performance, but it can also be considered at that point. But that's purely the board of directors' discretion on that.
Thank you.
And the key is there is no automatic increase
No automatic.
that would take place after you make your decision.
Okay.
Short of you making a decision later.
Okay. All right. Is everyone clear on that? Because that was a open question, a little bit confusing last time. Okay. And it's worth noting in the draft, there is a section that says, by memorializing these terms, the board is not seeking to block the executive from any other entitlements that they might, or any other benefits or the like that they might be entitled to. So there's a bit of ambiguity as to whether when the board takes over the structure of a compensation framework, does that then negate all other pieces? And the assumption made that the board would carry into it what it wants to carry in, and then nothing else kind of would apply. So the contract says very clearly that this is what the board is setting, but if this employee in their role as an unclassified employee in the organization is entitled to any other benefits by view of city civil service or anything else, we're not blocking their ability to obtain that. All right, any other questions? Thank you, Director Cole.
For bullet point 4 under performance evaluation framework.
Yep.
Will that align with the same timeline as the annual goals? I'm just trying to make sure there's like no moving goalpost, you
No.
know? Okay.
No, you're absolutely right. So the, what we anticipate, and is not, the timing is not spelled out in the contract because we want to allow the board to have flexibility to adjust as we had to adjust this year, right?
Right.
But the anticipated cadence is an annual review,
Okay.
as we outlined this year, and all of that would flow not just to General Superintendent, but also to Director Heyman and also to Special Counsel.
Okay.
So I'll have I hear a motion to, assuming there's no other questions.
If there's no further discussion on it, I move that we accept and pass the drafted version of the contract to the board.
All right.
Second.
All right, it's been properly moved and seconded that we pass, and I would interpret that as recommend.
Right.
Okay, to the board for review and approval. Is there any further discussion? Hearing none, all those in favor, signs of aye.
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 Any opposed? Any abstention? Motion carries. All right, one step closer. All right, the next item on our agenda today for discussion item is the Executive Leadership Emergency Succession Plan. And so you should have received a copy of that plan with your packet last week. Our Chief of Staff sent it out to everyone. It is, if I can ground everyone in sort of where we are with this version of the plan, the committee recommended and the board adopted and asked staff to provide a succession plan that incorporates the 3 executives that report to the board and any other critical role in the organization that staff saw fit to include. We've had a number of updates on progress on that plan, including a robust discussion, I think, during our last meeting, where we recognized we may not have been as specific. And so what we received from executives, gratefully, thankfully, was two sorts of plans. One was a workforce succession plan and development, and then an emergency succession plan. So we clarified during our last meeting that the intent really was for staff to provide an emergency succession plan, and then added the additional guidance that it should be in the form of a playbook, meaning it's easy to pick up, read, and understand what should happen next in the event of an emergency. So staff has gone away, made changes to the work product. I've reviewed it, it is dramatically improved, and so very, happy with where we are with it, but want to give the committee an opportunity to ask questions and provide any additional feedback. And then once we have done so, I'll hear a motion to sort of move us through. And if, Director Heyman, if you want to walk us through the plan, since it's relatively brief, that would be
Yes, I'll-
okay too.
Go quickly.
Okay.
Having a clear succession plan is the foundation of any well-run organization. Absence of clear succession structure creates operational risk, regulatory exposure, and institutional uncertainty. The plan we have before you today is for the executive director, general superintendent, and special counsel. First, with the executive director, we look at immediate actions following a triggering event that would make it such that I was unable to work. Implementation of delegated functional authority. Later in the program, you'll see who has authority to sign off on different amounts of contracts. And also we have emergency meeting of executive leadership team, of course, which would be primarily the GAO and the superintendent and the other leadership team to discuss next steps. The appointment of an interim executive director by the board of directors based on the order of succession, which is documented as being the chief of staff, general superintendent, is second to the CAO. And then we have implementation of communications protocol. Next, we have implementation of delegated functional authority. When a triggering event occurs affecting the executive director, the functional authority of the executive director shall be automatically delegated as set forth below. And as I noted earlier, contracts not to exceed $1 million would go to the general superintendent. Contracts not to exceed $1 million financial would go to the chief financial officer. Government affairs, board matters would be the chief of staff. Legal, federal, state, local regulatory issues, special counsel. Issues involving pay, benefit, disciplinary, civil services, chief administrative officer. The internal staff communications would go to the communications director, regulatory notifications to the chief superintendent, and public communications to the communications director. Now, emergency meeting of executive leadership team. When a triggering event occurs, the executive director, the chief administrative officer, general superintendent, and the chief of staff shall convene an emergency meeting with the executive leadership team to ensure operations of other initiatives continue to move forward. The appointment of an interim executive director. When triggered, the board of directors shall convene an emergency meeting to appoint an interim executive director. The order of succession, as I noted earlier, would be the chief administrative officer, and then it would be the general superintendent as a secondary appointment. Communications protocol. The board of directors shall coordinate with the communications director and other staff as needed to develop communications update materials and to distribute amongst employees and others. Now, if we look at the general superintendent emergency succession protocol, the general superintendent is the chief engineer of SWBNO, overseeing 14 major divisions, as you know, and more than 900 staff. The immediate action following the triggering event, assumption of operational authority by the deputy general superintendents, who will step right into place, implementation of delegated functional authority, appointment of interim general superintendent by the board, implementation of communications protocol. Next, you have the assumption of authority by the deputy general superintendent. When a triggering event occurs that affects the general superintendent, the deputy general superintendent shall assume responsibility, management, and oversight of all operational functions in their respective areas, which they are already delineated. Implementation of delegated functional authorities. When a triggering event occurs, that affects the general superintendent, the executive director shall assume responsibility for all legal and regulatory matters managed by the general superintendent. This includes regulatory functions associated with the utilities sewer consent decrees and matters involving State of Louisiana Department of Health, the State of Louisiana Department of Environmental Quality, and other regulatory agencies. The executive director, in consultation with the Office of Special Counsel, may delegate responsibilities for legal and regulatory matters on a case-by-case basis. The executive director is in consultation with members of the executive leadership team, including but not limited to the chief administrative officer, the chief financial officer, and special counsel, so delegate the general superintendent's authority to the appropriate individuals for the following. Signature of contract authority as defined by the internal policies and contract specifications. Emergency authority, this includes serving the incident commander during the emergency operation center activation. And then we also have the appointment of the interim general superintendent. When a triggering event occurs that affects the general superintendent, the board of directors shall convene an emergency meeting and appoint an interim general superintendent. The executive director, in consultation with the deputy general superintendent, may recommend an interim general superintendent to the board of directors for appointment based on current staffing conditions and organizational needs. Communications protocol. The board of directors shall coordinate the communications director and others as needed to develop communication update and materials distributed among employees, public officials, and stakeholders. Now, if we look at the special counsel emergency succession protocol, the special counsel leads and oversees the Office of Special Counsel, which provides legal counsel, litigation management, regulatory compliance support, procurement review, and public records oversight for the utility. The position is unique, as a city attorney shall be the attorney of the board. The city attorney shall appoint with and advise and consent of the board a special counsel who shall have charge of and conduct the legal business for the board. The Office of Special Counsel includes 2 deputies, 1 deputy special counsel for in-house and advisory matters, and deputy special counsel for litigation and claims. Immediate actions following a triggering event. Notification to the city attorney, appointment of an interim special counsel, and implementation of communication protocols. Notification to the city attorney. When a triggering event occurs that affects the special counsel, the executive director shall immediately notify the city attorney and advise that an appointment for an interim special counsel is needed. The city attorney shall serve as the attorney for the utility until an interim special counsel is appointed. The appointment of the interim special counsel. The city attorney shall appoint the interim special counsel. The executive director may recommend the city attorney an interim special counsel appointment based on current staffing conditions and organizational needs. Once an interim special counsel appointed by the city attorney, the board of directors shall convene an emergency meeting to discuss the interim and consider the board's consent of the appointment as required by state law. Communications protocol. The board of directors shall coordinate with the communications director and other staff as needed to develop communication updates, emergency succession, and quick reference. The following table illustrates emergency succession coverage, and here we just outline what I stated above regarding the executive director, general superintendent, special counsel.
Yeah.
And then you have the last, which is the emergency succession plan maintenance. Basically, the document shall be reviewed and updated no less than annually and upon any significant organizational change, departure, or restructuring.
Perfect.
And I think that's sufficient.
Thank you, thank you, thank you. So exactly what we were looking for. I have a couple of points of feedback based on my review, but I will defer to the committee to provide any questions or any feedback comments that you have.
I've got one.
Sure.
On the executive director's succession plan, at the end, we talk about the board of directors choosing an interim, and then we list people in the line of succession. I guess it's the CAO and then the general superintendent. Does that constrain us to just one or in that order necessarily, or could we go outside?
Go ahead, Director Hammond.
The document tries to make sure that we're able to continue moving forward. Okay, so it's those two. You could come back and have in your special meeting say that they have run the organization for 2 days. At this point, we wish to appoint so-and-so as the interim.
Yeah,
Or you would basically put the stamp of approval on the person that came up administratively.
okay.
Correct.
So yeah, I understand, okay, so between the time that somebody was
event
disabled and we were able to have a special meeting, then it would be those two people. And then at the special meeting, we could either continue with whomever took over or go outside and find somebody else.
Exactly, exactly.
I just want to make sure we weren't constrained.
Yeah, exactly. And that's the case for the general plan, is to give the organization predetermined and thoughtful direction so that it's able to continue to move, especially in an emergency situation, before the board has an opportunity to convene and decide. Any other questions or feedback that you want to provide before I jump into mine? Okay, so there was mention of the communications director and communications processes, in particular where there is an activation of authority or activation of delegated authority. We should probably spell out who will communicate that and when. I would also suggest, just around time, that we have some time-based actions. So within 24 hours, this happens. Within 72 hours, this happens. Within 7 days, this happens. Which will make it easier for anyone to pick up and understand what happens next. I would also have special counsel review and confirm that the appropriate board action is listed. So there's places where we say board appointment, board approval, board confirmation, board ratification. Just make sure we're using the right term.
Sure.
Okay, and then the last one is, there is some discretion for the ED when we talk about delegation authority of the GSO position. And I want to understand whether that's intentional. I would prefer for there to be maybe a little bit more of a presumption of deputy GSO or something that kind of give us a little bit more information other than the ED will determine who's next. Unless that is very intentional and we have some rationale for why we want to keep it.
Well, I think in the emergency situation, just like we did with the ED,
Yeah.
we have it administratively listed.
Okay.
And so it'll be a selection of the two deputies.
Okay.
And then after that point, and the board had its meeting, they can make a determination.
Yeah, so, and that's the feedback, right? Is the way in which we did it for the ED, that we have something similar for the GSO. And then for special counsel, you mentioned that the city attorney is our special counsel until such time.
Well, by law, the city attorney is a legal advisor to the Sewage and Water Board.
Okay, and so in the event that emergency happens and you are not able to serve, the authority goes back to the city attorney, or perhaps never left. But in the interim, between the time that we can confer with the city attorney and appoint a new interim or special counsel, there's a period of time, and the city attorney then has authority and responsibility. It might be helpful to note what happens, though. Okay, so what should your team do to empower and engage with the city attorney? Even though we know her authority is there, what do they need to prioritize matters? Do they need to confer, convey certain information? And I can send some more detail on what I'm thinking, but.
Okay.
But I understand what you're saying. They could very well say within 24 hours, they'll meet with the chief attorney, and at that point, we'll present a prioritization of cases.
Exactly.
Yeah.
Okay. But generally, with all of that said, I think it's excellent.
One question.
Yep.
So for the CFO, is that $1 million delegation, is that just referring to anything that's financial, or would that apply to the same authority that the general superintendent has for anything that's out in the field?
I'm sorry, I didn't hear the first part of your question.
So the $1 million authority for the CFO, is that related to just only financial aspects, or is that related to anything that can actually happen in the field with the same authority as the general superintendent for the $1 million?
Same authority as the general superintendent,
Okay. So they both could then sign off on,
up to 1 million
okay.
because of their positions.
And is that sort of what,
That is presently what the executive director has. That's not any different than what the executive director has.
gotcha.
Okay.
Do you have a concern, or we can go back and look at it?
So I would just think if Caitlin's available for anything that's actually in the field that's related to the field, and you have two people with the same authority, well, then someone can sign off potentially on something that the other person doesn't know. So what's the cross-reference in making sure that if Caitlin's the general superintendent, that someone else isn't signing off on something that she's not aware of or she has a different thought process about?
Okay, I respect that. Let us go back and review that.
Okay.
All right, thank you, Director Stewart. Any other questions, comments? Okay. If none, then I would entertain a motion to recommend review, approval, adoption of this succession plan pending the questions that have been raised in this committee meeting and any revisions that would be relevant as a result of that.
So moved.
Thank you. Thank you. It's been properly moved and seconded. Any discussion? Public comment?
No public comment, Chair.
All right. All those in favor, signs of aye.
Aye.
Any opposed? Any abstentions? All right. Okay, we can now move on to our two presentation items. Thank you to our staff for pulling together that succession plan so beautifully. We now will proceed with our 2026 legislative session and policy update by our Chief of Staff, Jamie Parker.
Good morning, directors. This is, I guess, the final legislative update of the year as the session ended earlier this month on June 1st. And so for my presentation, I wanted to focus on the legislative agenda that the committee decided on at the beginning of the session. These were our areas of focus, and I'm happy to say that we were really successful in these endeavors. So the first one was us striving to keep employees in city civil service. That ended up being House Bill 441. It was imperative for us to repeal that language this session to halt the implementation of that transfer, and that has been accomplished. So the bill has made its way out of the session, and it has been sent to the governor for signature. The second is a two-part initiative to ensure that we have a legal path forward for our lead service line replacement program. So this Senate bill was proposing a statewide constitutional amendment to allow us to use public funds on the customer-owned portion of property to replace lead service lines. As we recently shared, we do have a favorable Attorney General opinion that supports this and notes the substantial public health benefits. But moving forward with a constitutional amendment just solidifies that we are able to take this step. So this bill has also made it out, and it will be on the ballot later this year in November. The companion legislation to that is Senate Bill 268 that has also been sent to the governor for signature, and that allows municipalities to carry out lead service line replacements without necessary delay. We will be focusing our efforts on those properties where we receive right of entry from property owners, and there's a multi-step process that we will follow with multiple notifications. So we are excited that we will be able to move forward with this important program with this piece of legislation. And then finally, when it comes to our internal processes and procurement, This became House Bill 893, and so now our procurement processes align with those that are followed by other agencies throughout the state. So just trying to create efficiency here and make sure that we're operating the same way as other agencies. This is also pending the governor's signature. So this, as you might recall, was the first time we tried to be proactive and take a holistic look at some of the issues we were facing, identify those, work with our local delegation to find a bill sponsor, and then navigate through the session. So I think this is great news that we were able to accomplish this session. And then finally, a note on capital outlay, which I believe is also good news. We were able to secure $9.5 million in new funding for our water treatment plant improvements. And we were also able to successfully get reauthorization for $3 million for our power complex, and then $750,000 for work on the Monticello Canal culverts. So a great effort from the team and our city partners and state delegation in getting us some much needed funding for these capital projects.
All right, thank you, Jamie.
If I may, I did want to just applaud Jamie, Gray, Caitlin, doing a great job we had several meetings going back and forth, organizing what we were going to do, trying to be very strategic in what we were doing, and the end result was success in this action. So thank you very much.
Absolutely, absolutely. Any questions for Jamie or for staff?
A couple, I think.
Yep.
The constitutional amendment. I think we had talked a couple of meetings ago about if it does fail, there's the Attorney General's opinion that might declare that we don't necessarily need it.
We got both of them, right?
I'll defer to special counsel, but I believe this is like an extra step of
That's pretty much, that's
yeah.
what a belt and suspenders approach.
Okay. Yeah, my concern is usually without default for Louisiana on constitutional amendment is no, unless it's something we really.
We got the favorable opinion from the Attorney General's office, and we continue to pursue and request that we get that constitutional amendment as well.
Okay.
Because sort of like I said, belt and suspenders approach, in the event it doesn't pass, we still have the agency's opinion.
We're still good. Okay. And the other one was the 9.5 million's in priority 2 capital outlay. And my experience with that is that you got to keep on pushing to see anything out of that moving forward. We have a plan to try to get that bumped up to priority 1 or put in the queue
It's my
quicker.
understanding that since this is the first year, it would just go to P2, but there's no reason that the State Bond Commission cannot take action to authorize those funds, is
Okay.
my understanding.
So yeah, you have to, but you have to like,
Correct, there still has to be, that would be the next step, would be the State Bond Commission has to take
Okay.
those actions.
All right.
So it's authorized and has to go through the next steps. So this is not the funds aren't immediately available,
yeah,
immediate.
that's what.
But, so you make a good point, though.
Okay. And so, Caitlin, can you expound a bit for the committee on what next steps might be and sort of what we are intending to do with these funds when we can anticipate them actually being put into use?
Sure. And just as a matter of time, I think we will have to go
Yep.
just a couple minutes. But yeah, so the water treatment plant improvements was a new application, $50 million over 5 years to support more immediate term projects while the longer term approach for the water quality master plan is being developed. So we have 3 projects initially identified around some filter improvements, lime storage, and some river intake piping.
Okay.
So the process is that the bond commission, state bond commission, has to take the step of authorizing those funds, and then we work with the city. The city is the official delegate of the funds, and then we work with the city and enter into a CEA with them, and we work through with the city as well as the Louisiana Department of Administration, the State Capital Outlay Group. So we're very familiar with that with the power complex. It's just the money is authorized in June and usually is not available administratively until the end of the year.
Okay.
Yes, ma'am. Okay, I got it. All right, any other questions, comments? All right, thank you. We will move on, and I know our I'm sorry.
Public comment.
Okay, public comment,
Public
let's go for it. We're not done yet.
May, I apologize, but we do need to leave to be on time for Public Works Committee meetings.
Because it's on the side that we just spoke.
Okay, that's fine. All right.
Kennedy Moore from the Water Collaborative. Yes, you have 3 minutes.
Hi, my name is Kennedy Moore. I am the State Policy Coordinator for the Water Collaborative, which is a local nonprofit based on community-driven policy solutions and specifying water quality. I just wanted to let the committee know that we are in support of Senate Bill 228. We're very happy that it passed. And due to its nature of being on the ballot in November, the Water Collaborative is open to any support when it comes to educational outreach. In addition to that, a lot of the data that was provided for this bill came from our 2024 lead study based here in Orleans Parish. So we're happy to provide any additional data in terms of educational outreach as well, and in the future for any upcoming water quality testing.
Thank you, Kennedy. Thank you.
We have Michelle Palat.
Yes, I would just want to echo the fact. I'm excited that the lead replacement program is moving forward. I just want to make sure that when we talk about the rights of entry and those who have granted that it's equitably done through that process. I understand this might not be done through this committee, but that's very important for me to make sure it reach those who are at risk. And if there could be an at-risk thing put on this, that would be great. My also thing was that you're dedicating a lot of money to the water treatment plant. I don't know the exact number now, but I believe over 70% of the water that's leaving the water treatment plant is lost. There are many major leaks throughout the city. I just think the fact that we keep putting money toward the water treatment plant, but once that water leaves that plant, majority of it is lost through the piping systems. So I really encourage the board and governance to move towards securing the water that leaves the plant instead of keep pumping water out the plant, because we're losing, I believe, over 70% of it, and we have smart meters that are now leaking. So can we improve that process? Because I see a fact that we are pumping the water out and treating and repairing for that, but immediately once it leaves, we lose it. And it's causing all kind of subsurface problems throughout the city. Street repairs are being caused because of water main leaks. I have personally documented along Dwyer many, many leaks. Interagency coordination need to be improved with Entergy as well. When Entergy is replacing poles, there's one right now at Dwyer where a utility pole is busted open a pipe and it's been leaking there for years. I identified this since January of this year and notified the Sewer and Water Board with all 22 infrastructure failures along Dwyer, which I've documented. I will say I'm thankful that the sewage situation is being addressed by the administrator and the general superintendent. I'm thankful that we have made improvements on the sewage issues. And I want to thank you all for your efforts. And I want to thank Ariane, our District E liaison, for being attentive to the community throughout the process. Thank you.
Thank you. All right. All right, any other public comment?
No other public comment.
All right, we'll go on to our last presentation item for the day, and that is the governance transition assessment, which will be provided to us by the Office of Special Counsel.
And here to present on that matter is Deputy Special Counsel Mary Arsenault and Assistant Special Counsel Theron Levi Baquet.
Thank you.
Good morning, and thank you all for having us. I'm going to do a quick overview, and then Darren is going to explain in more detail what the elements are that we have to report on today. There are two. First, there is House Bill 1243, and I have copies that I can pass around for everybody to have their own version to take home. Help you go to sleep at night, maybe. A little boring information there. Also, yeah, thank you. Also, the executive order that was recently issued by Mayor Moreno on this same subject, because the House bill awaits approval by the governor, or rather non-veto, because if he signs it, it takes effect. If he doesn't veto it, it takes effect in either case on August the 1st.
Okay.
The bill passed in substantially the same form that it was introduced. The only significant amendment that was made was with respect to the very beginning of the bill that restores the introductory paragraph about the charge of responsibility to the board in the current law. So that stays the same. That the public water, sewer, and drainage systems of the city of New Orleans shall be under the maintenance control of a sewage and water board. Theron's going to talk about what it means for the language that changes the structure and the control of the board.
Thank you.
The bill then confers a lot of administrative authority over the board. Theron's going to talk specifically about those listed categories and what that will mean. Some of that is also anticipated by the executive order that was issued by the mayor. And you'll see, and again, we're going to talk a little bit more in depth about that, but the mayor has broken down various elements of implementation issues, both in the immediate term and then the longer term. And she's created an advisory group. It's a subgroup of the infrastructure group that she created in February. This advisory group is intended to look at the short-term and then long-term kinds of issues that are delineated in here for potential action based on study and collaboration. So without further ado, that's the overarching scenario, and then Theron is more familiar with in his PowerPoint presentation on specific areas of impact.
Thank you, Mary Beth. Good morning, committee, Chairperson Scruggs. As Mary Beth described, she kind of gave an overview of what we're going to explore today and hope to get into some details. Understanding that this will be an ongoing and evolving assessment, we wanted to kind of address the most pressing questions, but then also kind of set up model how we anticipate taking this information from various sewage and water board subunits, evaluating it, analyzing it for legal implications or risk factors, and reporting that back to the committee.
Awesome.
So first, just a bit of an update on House Bill 1243, which Mary Beth pretty much covered most of this. Since our last discussion here at a public meeting, the bill has, of course, received passage in the House and Senate. It passed unanimously out the Senate and went for concurrence to the House, where it also passed unanimously. It was signed by both the Speaker of the House and President of the Senate and sent to the Governor for executive approval on May 29th. As Mary Beth mentioned, the bill will become effective on August 1st, unless it is vetoed, of course, or signed earlier. In any case, August 1st is our target date for the effect of this bill. In that earlier timeline, there was a mention of a Senate amendment. So after the bill was sent from the House to the Senate, there was a slight change. The initial version of the bill, or the earlier version of the bill, I should say, explicitly stated that the Sewage and Water Board would be a state entity separate and apart from the city of New Orleans. That reference has been removed. It still maintains the provision that the composition of the board will be set forth as it is in the Home Rule Charter unless provided by other law. The effect of this provision largely remains the same, except the removal of the state entity designation. So a final look at what the language now says. So we have that the public water system, sewage system, and drainage system of the city shall be controlled by a Sewage and Water Board. That is essentially what the statement was in the law before HB 1243 made any changes. The composition will be set forth as it is in the charter unless provided by other law, and the council may by ordinance and in accordance with state law prescribe rules and regulations governing the appointment terms and service of board members.
Just a quick question for you, Theron. In the first sentence, it says operated by a sewage and water board, and then the second goes into composition of a board. So, obviously those two terms of board and board are not defined, but it sounds like they are they're used, or they have different meanings in each of those sentences. Is that your reading as well?
The statute doesn't, it's not exactly uniform in its reference to the board and board, and obviously, as an organization, we've kind of used those interchangeably. I do believe that the first reference to being maintained and operated by a sewage and water board does speak of the organization.
The whole
Yeah, the whole
organization.
organization.
Correct, okay.
And then obviously the composition refers to the board of
The
directors.
board of directors.
Yeah.
Okay, all right.
All right.
Um,
So as, oh, I'm sorry, go ahead.
Can on that, kind of on that point though, if you look at the bill, it deletes a lot of the provisions that you all are familiar with because you went through the process with the nominating committee. That is all being deleted out of current law.
Yeah.
So, yeah, that's being removed, and the provision in the bill
Mhm.
gives it to the city council, I suppose.
That's accurate.
So, yeah, thanks.
So, of course, in tandem with the legislation, the Moreno administration, the mayor's office, has put forth Executive Order HM 2604A, which creates the Public Utility Modernization Process Subgroup, PUMPS. Just a brief overview about what this executive order does and what PUMPS seemingly is charged to do. The order establishes a standing working group of the Infrastructure Coordinating Council, that's a city council subgroup, and PUMPS would be a subunit to that group. So it is charged with assisting the ICC mayor and city council with the immediate implementation, of 1243, and a longer-term transition to a local control governance model for the Sewage and Water Board. So it is kind of multi-part, as Mary Beth mentioned. There's some immediate impacts that the city is looking to implement and kind of work on the process for implementing, pulling the Sewage and Water Board into the city over the long term. It will consist of members appointed by the mayor, including representation from the city council. This includes the council president, the chair of the Public Works Committee, or their designees. The executive order does not state a minimum composition for the committee, nor does it state a maximum. It doesn't specify, exactly who will, but it does specify the council president, Public Works Committee chair, or their designees. As needed, it will include subject matter experts in the areas of law, public policy, municipal finance, engineering, utility regulation, labor, and project management. It is charged with making recommendations to the ICC mayor and council on governance, oversight, and transition issues related to HB 1243. And you guys do all have copies of the executive order, so I won't read them all for you, but you can kind of see that the idea seems to be to create a think tank of sorts to evaluate policy ideas, make recommendations to the council, the mayor, and the ICC that would or could eventually result in ordinances affecting SWMNO operations or governance.
Okay.
All right, and the longer term responsibilities of the group are similar to the shorter term. The short term is more focused on implementing HB 1243 as passed, and again, the longer is focused on integrating SWMNO back into the city of New Orleans. Kind of specifies how they plan to accomplish this, but it's essentially the same. Assessing operations, making recommendations, evaluating policy ideas, and kind of reporting and making recommendations to the city council, the mayor, and the ICC. Importantly, as an operational unit of the ICC, PUMPS is not a mayoral advisory committee, as that term is defined in Section 4104 of the Home Rule Charter. This means that its meetings will not be governed by the Open Meetings Law. HM 2604A does explicitly state that the order does not alter SWMNO's legal status. It does not transfer any asset, impair any contract or bond obligation. Neither does it limit the authority of the legislature, city council, or this board of directors under existing law. Right, so we do want to talk about what we think are some crucial near-term impacts as we perceive them.
Yep.
Of course, the bill will be effective August 1st. What the intended impacts are, we won't know. Obviously, this isn't our legislation. And then there's also the fact that the council must enact ordinances that kind of further the authority that they would get under HB 1243. Importantly, there is non-impairment language now throughout the bill, which does protect any existing contract obligation. We understand this to extend to bond covenants, contracts related to grants or funding agreements, infrastructure projects, or public works, or construction contracts, or contracts for services.
Yep.
So we do think that operations are, as they are in place now, are safely maintained, that nothing in the bill gives the council the authority to kind of undo any act that we've entered into by contract. One of the most certain immediate impacts would be the removal of the mayor as the ex officio president of the board. This is by amendment to revised statute 334073. The mayor would, as we understand, remain a member of the board, as that is in the Home Rule Charter, but the Home Rule Charter provision does not specify that the mayor is the president of the board. So it may be the case, unless some other action happens between now or after the effective date, that a president may need to be elected from among the membership of the board by members of the board as the statute now mandates.
Okay.
The legal authority for customer advocate designations for 2 members of the board will be stricken from existing law, from Title 33. These are not codified in the Home Rule Charter, so these designations may no longer exist. This is a potential area of ambiguity, I think, in that the mayor has made these appointments by official act.
Yep.
So we might need further information or direction from the administration on whether the current customer advocates continue to serve, what the plan is going forward, but they will not be in state law. In terms of impacts to contracting, as we stated, there are some various non-impairment provisions in the statute. So any current obligation we have under contract, these appear to be unaffected. And again, this extends to bond covenants, funding arrangements. But beyond this, our contracts, the process for the organization sort of entering into contracts is governed by Louisiana Public Bid Law, as we know.
Yeah.
This applies to public works and materials and supplies agreements. This is existing law. So the process for procuring materials, supplies, services, we perceive to be unaffected by HB 1243. Any changes that would be enacted can impair requirements from the public bid law, which do very duly apply to the Sewage and Water Board. In terms of professional services procurements, that is governed by Policy Memorandum Number 95. In Louisiana law, the bid law does not apply to contracts for services, but guidance, administrative guidance, and a lot of case law directs organizations to establish a routine competitive process for entering into agreements for services. The Sewage and Water Board's process is codified in Policy Memo 95. That policy was actually sent to, evaluated, and certified by the city when it was implemented, as was the requirement at the time, so the city has approved that professional services procurement policy. If I had to make a statement, I would say the Policy 95 is obviously a little bit more vulnerable since it's not an established law, but
Okay.
is again a policy that the city has approved, and it is virtually identical to the professional services policy that the city uses itself.
Okay.
Again, just more information on that as existing state law. The requirements of the public bid law as applied to the Sewage and Water Board cannot be undone by HB 1243. We think this extends also to obligations related to pension management and funding. As these obligations are largely, managed by contract, they can't be undone by the bill. In terms of emergency preparedness, we did want to communicate that the primary authority for the Sewage and Water Board's emergency operations is in a statute, revised statute 334084. That provision of law was untouched by House Bill 1243. So the authority for the Sewage and Water Board to enter into contracts to respond to emergency scenarios without the requirement of going through the formal procurement process is unaffected by the bill. The Sewage and Water Board still has the authority, obviously, to issue emergency declarations and declarations of extreme emergency to respond to, events in the community. This is also unaffected by the bill. Contracts for emergency services ahead of this hurricane season. It is our practice to procure these services before the start of hurricane season.
Okay.
And virtually all agreements that are, emergency response agreements are in place as of now. Again, these would be unaffected, obviously, by HB 1243.
Okay.
Of course, don't want to speculate on what the intentions are of this legislation or executive order, the whole process, but we do think that the long-term intended impacts of this bill and executive order are best described by the language of the executive order, which again is over a longer term to transition the Sewage and Water Board, or transition, excuse me, into a local control model for the Sewage and Water Board. In the near term, it is the immediate implementation of HB 1243. Whatever that means, the city intends for it to mean, and we will, of course, understand better once we start to see ordinances coming out or information from the working group. Going forward, I just wanted to say a bit about how we plan to, I guess, analyze information that we get from other SWIBNA subunits. This is kind of a legal-focused analysis of the immediate impacts, but we do think it's important to solicit input from the GSO's office and also the CFO's office about what they think perceived impacts of this would be. So we want to solicit that input. We kind of plan to cross-reference or cross-analyze it by the areas identified in statute that the City Council may look to kind of implement changes in. What we plan to do is kind of request this input from those departments, run that analysis, and have them speak to what they think the perceived impacts or risks of implementation might be going forward. And ultimately, this lovely graphic was shared with us. We thought it might be useful to evaluate risk of implementation in a matrix, something like this. We do, of course, intend to have staff collect this information, document it, and we can present going forward in a fashion similar to this. Of course, open to comment or further directive about what we'd like to see.
All right. Thank you so much. This was a great overview. Open to the committee's questions or comments. I'll ground you in what we asked for. We did ask the staff to go away and help us understand the changes that were happening, what the potential impacts might be, both legally, financially, operationally, especially as we head into hurricane season. So it is reassuring to know that contract obligations are protected uniformly across the board, and also that our emergency preparedness procurement process has put contracts in place. So we are at least set for hurricane season. Any questions or comments for Theron or the Office of Special Counsel on this?
A couple of questions. Excellent presentation, by the way. And I'm glad you brought up the pumps because I'm getting a couple of questions about that, and you may or may not have the answers. So do we have any insight on composition of that? Like, have we gotten any feedback? Because I'm looking at the part about the subject matter experts, right? And I believe on the slide you said that from a transparency piece, that like they're not required to have open meetings,
Right.
but they could, right?
Right.
Okay.
Yeah.
They've said they don't have to have open meetings.
Right.
Okay.
So they,
Because of the nature of it being a subgroup. That's in the executive order.
Okay. But that doesn't mean that they can't necessarily have them. I'm just wondering because people are asking like, how are we going to get this input? How do we know that subject matter experts are, you know, going to be able to be a good representation in the think tank kind of thing?
No, I think Mary Beth kind of answered it accurately. They've reserved the right to not report on a open meetings basis, but I think there is language in the executive order that says that they're not intending to limit any kind of communication. They still can. Nothing prohibits them from reporting out what they've discussed or holding minutes and posting those publicly. In terms of composition, beyond what is in the executive order, there really isn't. I don't have much insight into who would be a part of it. I do think this is HM 2604A is a sub-executive order to HM 2604, which establishes the Infrastructure Coordinating Council itself. The Sewage and Water Board is a part of that group, but not by the terms of the executive order a part of the pumps group.
Okay. And thank you for pointing that out. Because that was my other question. It's like, what would be the engagement piece on that? Considering they're going to produce some things that should be that's gonna amend how we're operating. So I was just wondering what the engagement part was on that. And then the risk assessment, as far as staff producing that, do we know right now like a timeline on that? Or is this like just kind of the first time we're saying, hey, can you all come back to us? I was just wondering how long that would take.
Kind of the latter. I think we want to just give opportunity for the most relevant subunits of the board to kind of report back to us, maybe give an analysis of what they, like we mentioned, see are the biggest risks of implementation with an eye toward the statute and the pumps executive order. I can't really give a time frame, but obviously we want to be very thorough and intentional. But we hope, I think, to give updates, staff does at each meeting as we can or have new information.
Okay, yeah, that would be good considering I believe that with pumps, they were trying to do some things in a couple of months. So I think that we should probably try to align on, if we're not gonna have the direct engagement, at least if we can kind of, put things out there so it's able to be engaged in that manner. So, okay, thank you. That was just.
Go ahead, Director Cole.
Clarification. The pumps group is gonna develop a plan to what they're gonna do with sewage and water board, right? Keep it the same with changes, fold it into city government, et cetera, et cetera. Whatever it is they do is gonna require a city charter change, probably state law change.
Well, not exactly.
That
It's
was
not
the
our
purpose, the
understanding.
whole purpose of this bill was to give it to the city council
Okay.
through ordinance authority.
It'd be like more like ordinances.
Yeah, that's right. The composition of the board may require a home rule charter change because there's already language in the home rule charter about what the composition is.
Okay.
But if an area is, not specified in the charter, and now the city council has the legal authority from state law to issue an ordinance directing our action in that area, then it wouldn't require any change to state law. The city council could, by ordinance, direct us to, change our processes or.
Yeah. Go ahead, Director Cole.
All right, because it says that shall be governed by a sewage and water board, basically controlled by the city of New Orleans. That's the state law.
That's current law. As
So to
well.
completely just say, all right, y'all are gone, we're taking it over, it's part of DPW now, just a what-if scenario, that would require a state law change?
No, current law says, no, that wouldn't take I don't think that would take a state law change.
Well, if you wanted to abolish the sewage and water board as a body,
Yeah.
that might
Correct.
require a state law
The
change.
whole entity.
The whole
Yeah.
entity.
Okay.
But in terms of like replacing the composition, we don't perceive that would require a state law change.
The Board of Directors.
The board of directors.
Okay.
That's where that language is getting.
References
That's
to
where I was
board, right?
confused.
Okay.
Okay,
Okay.
all right.
So your question is about the existence of the utility and the
Yeah.
purview of the utility, which is in the law. But the composition of the Board of Directors is in
Yeah,
the
that's
home rule charter.
completely up to, okay. That's
Okay.
where-
Home rule charter is based on the state statute that was in place until about 3 years ago,
Mhm.
Okay.
where the litany in the current law that says that there shall be, the board consists of the mayor, 2 members of the Board of Liquidation,
All the.
Seven
all
mem-
those
yeah.
Things, yeah.
That structure, like that, appears in the city charter. What doesn't appear in the city charter is the language that was in the statute that said the members of the board are supposed to be representative of the population at large, one from each council district, supposed to have certain areas of knowledge and capabilities. All of that is out of the law now. That kind of thing will be under the city ordinances now,
Okay.
because that's where the power has been given, is to the city to define qualifications in terms of office and so forth. So I don't know that I would say it was a gap, but the current board is in office. The current board is in office under the current structure that has staggered terms. That's not been changed. So there's not been a provision for changing that. As far as a matter of law, it may be moot.
So,
Right.
thank you, Mary and Darren. I just want to ground us on the reason for asking for this assessment and the discussion. We understand that the Board of Directors construct composition is under review, and there will be some recommendations and some actions that will take place. However, there is an authority shift and a potential process shift that's beyond this body. And we're trying to understand and help prepare our organization for what we can anticipate and what we don't know, right? A part of that is identifying questions that might be critical and then trying to seek answers to those questions. And so in our next iteration of the assessment, let's try to hone in on the areas of ambiguity that might have a moderate to high impact, and then see how we can maybe seek to get some clarity and answer some of those questions. For now, it sounds like the assessment says, for hurricane season, emergency preparedness, we're solid, right? The contracts that we need, the resources that we need to go have already been signed and put in place, so there's no ambiguity as to the authority and processes with regard to that. We just heard from our executives on the emergency succession plan, and so we're very clear on how all of that works, and it doesn't seem like any of that is impacted by this shift, right?
Right.
Okay. All right, so that was our primary concern, was in heading into hurricane season, which is a high-risk season, and heading into a governance transition, which could potentially be high risk. Do we understand the risk at a more granular level? And then are we doing what we can to mitigate? And it sounds like we're heading in a good direction in both of those. All right, so continue to ask your questions. If you hear from constituents, ratepayers, taxpayers, whomever, that are unclear about things, feel free to raise those questions, to raise them directly to the Office of Special Counsel, and they will collate those things and come back to us with any new information, any answered questions, any new questions, and any other areas of risk that we should consider. Okay? All right. If there are no other questions or comments, that is the whole of our agenda today. Is there any additional public comment?
No public comment, Chair.
All right. Hearing no public comment, I will entertain a motion to adjourn.
Move for adjournment.
Been seconded. Any questions? All those in favor, signs of aye.
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 Opposed? Any abstentions? All right, meeting adjourned. Thank you.